Good evening. It is our pleasure to be before you once again on behalf of the Cook County Bar Association, the world's oldest African American Bar Association. Chris, I love saying that, but technically, we are the oldest African American association of African American lawyers, actually older than the National Bar Association. Our founders actually played a large part and founded the National Bar Association. And ladies and gentlemen, you're in for a treat because it is the job of the Cook County Bar Association to bring you information that you can use, practical information, community information, state-of-the-art information. And today we have a friend of mine I don't see as much as I used to, Krista Ashley, who's just been out there a long time, not super long time, but she's a veteran attorney. Krista, how long you been practicing?
20 plus years now. It's 20 plus years, so.
Well, Chris, you've been out there doing the people's work, still doing the people's work. Tell us a little bit about yourself.
Well, I'm an attorney. I'm a sole practitioner. I practice in Chicago. Most of my cases are in juvenile court and child protection. Prior to that, I did work with legal service agencies, community law project.
Talk about the community law project a little bit, Crystal, because that's how I got to know you.
Right. That was a long time ago, fresh out of law school. I think I was, just associating with the Bar Association, and they had a legal service program called the Community Law Project, and we used to handle cases for low-income people, housing, consumer protection, some uncontested divorces. But anyone could come into a neighborhood community and get an assessment of their case by a volunteer lawyer, Cook County Bar Association lawyer, and a referral to what program might seem to be appropriate for them, or depending on what their legal issues were.
And that key word, Crystal, is free. Because, there are not a lot of free services, because as a matter of fact, legal services are dwindling. So anytime you have an organization that's able to put out attorneys to give people information for free, offer assistance when they can for free, that is a tremendous thing.
Right.
Now,
well, I think that's something that we do as African American attorneys too. We offer free consultations often.
Ladies and gentlemen, the Cook County Bar Association is your bar association under the direction of Yuri Clark, who's having a marvelous year. And the Cook County Bar Association, our goal is to bring services to the community, to encourage people to use our attorneys, okay? Because if our people are not using our black attorneys, then we starve to death for the most part. So it's a twofold relationship. Now today's topic is child protection.
Right.
Crystal, could you elaborate on that just a little bit? Just explain it.
Well, child protection is the juvenile court center is not that far from where this location that we are at now. So Roosevelt and Western, and it's designed to provide protection for children who might be at risk of harm in their home environment. So. What I'm talking about is the law is the Juvenile Court Act, and that law is intended to protect children from harm in their home. And so the whole court system is structured to look out for the needs of children who might have come into harm's way, and to try to reunite families to find out what the problem is, why the child was in harm's way, and try to get that family back together by offering its services through the court system.
Well, ladies and gentlemen, we want you to call. The number is 312-1060. Again, that's 312-738-1060. Call us. Now, Chris and myself, we can talk all day, but this is an interactive program. We want some folks to give us a call. Now, case in point, Clyde McDonald, okay, the young man that was shot, 16 times, okay?
Yeah.
Was he a ward of the state?
He was a ward of the state. Yeah, my understanding is he was a ward of the state. He was not in his mother's custody. I think he was ultimately placed in the custody of his uncle.
Mm-hmm.
But yeah, his his case was in the juvenile court center. I feel like I should back up and just go through like what a typical what starts a typical juvenile court case. Initially, there's some incident in the child's home or in the home of the parents that has put the child at risk. And so there's an investigation.
Who starts the investigation, Crystal?
Well, we're really talking about the Illinois Department of Children and Family Services. They have their own child investigators. When there has been some type of injury or accident with the child.
Who prompts the call? Does somebody call?
The call can come from a number of sources. It could be the result of a police report. The police may have been called to the house because of some incident, and the police decide that no criminal act has occurred here, but there is a safety issue here concerning children. So they may call the Department of Children and Family Service investigators in to try to address the situation and see what it is that the family needs to move forward. In the Quan McDonald's case, I think he was what was he? He was a young adult, 15 or 16.
I believe so.
So I wouldn't know the details of the case as to when or why his case came into the system. But once it's in, the court will review the circumstances of why the case is in the juvenile court system every 4 to 6 months to see if there is some changes or some services that need to be put into place to keep the child going in a positive direction. Now, so in Laquan McDonald's case, I guess we can all know just from public records that things were not going in a good direction. And so you can say that the Department of Children's and Family Services struggles sometimes to get the proper services in place for a family. And families may struggle, to get the needs of the child met.
Again, that number is 312-738-1060. 312-738-1060. Crystal, what are the basic laws that govern this area?
It is the Juvenile Court Act. Like I said, it's the Juvenile Court Act that provides for, is designed to protect children from harms that may come to them as a result of incidents that might occur in the home. I'm being vague about that because it's a variety of things that can occur. Let's say, for instance, a child breaks his arm. Now, there's that happens. Children get into things and they hurt themselves. If the child is taken to the hospital and the doctor says, "Oh, okay, well, this was an accident," that's not an issue. 2 or 3 months down the line, the child breaks his other arm, and he goes back to the hospital, and the doctor looks at it and says, "Well, wow, this kid is kind of accident prone. What's really going on here is what's being reported to us about the child's injuries. Is that making sense now?" So, this might be a notation in the file. This seems unusual. This child has hurt himself again, unless there's some circumstances where he's in some type of strange sport where he's always hurting himself.
Well, Crystal, is there in terms of the doctors, okay, is there a number of incidents, or is it in the doctor's discretion to report the mother or the parents to the authority in terms of how many times he sees something that could possibly be a problem?
It is in the doctor's discretion, and most hospitals have a trauma team or a set of child protection doctors who kind of assess situations, incidents and accidents, and based on their medical experience and knowledge and everything, they make a determination as to whether the medical report and what the parents are reporting, does it line up? Does it seem like it was an accident, or does it seem like there's some other circumstance that may have caused this child to be injured, and that would trigger a finding, or what is called an indicated report, some reason to believe that some type of child neglect or abuse has occurred.
Hold that point. Ladies and gentlemen, again, I encourage you to give us a call. That number is 312-738-1060. 312-738-1060. And this is for everybody. This is for all concerned folks, so forth and so on. And also, again, this program is put on by the Cook County Bar Association. We want you to know your bar, because we are the people's bar. As a matter of fact, our information is as follows: 312-630-1157, 312-630-1157. You can hit extension 1. If you want to perhaps hire an attorney, you just listen to the prompts and be patient and just punch in a prompt that responds to the Cook County Legal Referral Program. Again, this is your organization that we are here for you to help. Now again, indicator. You said indicator.
Right.
Break that down for our audience.
Yeah, that's one of those. Juvenile court, it does have like its own vocabulary, its own lingo, and so if you're not familiar with the the definitions of some of these terms, it might seem really, really unusual, weird the way things are going down. But an indicated report just means that they think that there is a significant evidence of some type of misconduct or something in terms of a child's safety. It's all about determining whether there's been some type of safety risk concerning the child. And so if there's an indicated report, that is an administrative finding that that the Department of Children and Family Services suspects there's been an abuse issue concerning the child. And the next step is whether the state's attorney's office will decide whether that is a sufficient reason to bring the case into juvenile court to take temporary custody of the child, to remove the child from the home and find an alternative home for the child until the issues that caused the indicated report to be found are addressed.
Well, Krista, who are the parties? Who are the parties in a case like this?
Well, the parents, the child. Again, the state's attorney's office would file the petition, and the public.
Who represents the child, technically? Who represents the child?
The public guardian office represents the child.
Okay. Now, what is the role of the state's attorney?
The state's attorney is the prosecutor. The state's attorney is the prosecutor. Kim Fox was the state's attorney's. Was in the child protection division of the state's attorney's office initially, and so she builds some of her litigation bones in the state's attorney's office, and I think the child protection is near and dear to her heart as a result of her work there.
Does the parent or the parents, do they have a right to have counsel?
The parents are appointed by someone like myself, and I'm a bar attorney, so that means that the court would appoint me to represent the parents, either the mother or the father, sometimes both, or the parents are represented by the public defender's office. So you have several attorneys. You have the state's attorney, you have the public guardian, and you can have the public defender, and you may have representing the mother, and you may have someone like me, the bar attorney representing the father, and then you also have DCFS.
Question: is it possible for for the individual parent to have their own counsel?
Yeah, they could hire an attorney. In most cases, they're low income and they qualify for a public defender or a bar attorney. But if they were of sufficient income, they could hire a private attorney. But it is a really specialized area, and so the only private attorneys that would really probably pick up on the process that takes place in juvenile court is probably criminal law attorneys. A lot of criminal law attorneys also practice in juvenile court.
Okay, very good. Crystal, what is this term adjudication?
That's the trial. You can really compare the juvenile court proceedings to criminal court proceedings. So you have the adjudication is the trial stage.
Crystal, hold your point. We have a caller. Caller, are you there?
Yes, and good evening. And also, thanks for taking the call. And to that young lady, you got your game up tight. It's really tight. The question, you mentioned something that has always been curious. I ain't never been to a criminal court, but I have been in courts where sometimes 4 or 5 lawyers are there. And when you get that many lawyers in court and the judge talking, you're going to hear a lot of words you don't know. That's why it's always good to keep a recording so when you get through, you could go over some of the stuff that you heard and said. And the problem is this, though, seriously. Maybe the people that's being in court, being represented by these attorneys, and they start hearing words they don't say. Because I'm a true believer. I taught my kids all the same. When you don't know nothing, raise your hand and ask. And is it fitted to be able to tell the judge or the attorneys, listen, I don't know what you're saying. I don't understand what you said. Can they take time out to explain things to you? Because like I said, you get too many lawyers in the court. They talking chicken, and here you just talking pig Latin. You don't know what's being said. So I guess it's sometimes to find out what is being said. Or is it just necessary you have to wait for court is over when you get to your attorney and things like that? But can you ask the judge, please explain things to you? Listen, thanks for taking the call. I hope that wasn't too...
That was a good question.
No, it's a good question. That's
Okay,
an excellent question, and it really is an important part of the process. But the court, you're right. You've got all these lawyers, you've got all these professionals, and you've got a judge who's trying to move on with his day. He's really trying to move his caseload, and so you really have to just remind us that you don't get it sometimes, and it depends on the judge. I mean, some judges are really patient and they'll just say, okay, let's just take 2 minutes and break this down, and you can really appreciate that, because a lot of times it's the same information that the lawyer may have explained to the client, but it just helps the communication if the judge takes the time to repeat it, because in juvenile court can be a rather intense process. You're talking about dividing up a family. Emotions can run high and things can get confusing, and so if the language is off, if you don't understand different stages of it and you need a minute for to hear it twice, it's worth it for the public to really know. another part of that is that these proceedings are kind of confidential, because you're talking about the lives of children, and so you don't want to have well sworn to a level of confidentiality or privacy, because that's typically in the child's best interest.
Very good. Crystal, what is a permanency hearing?
The permanency hearing is the review process that the court engages in every 4 to 6 months. After the trial, the next stage is a dispositional hearing, which is sort of like in criminal court is sort of like the sentencing. That's when they decide whether the child should stay in the system, become a ward of the state, or remain as a foster child, or can that child go home? If the court decides that the child is going to remain a foster child, every 6 months the court is going to look at that situation again and say, well, can we send him home now? Well, can we send him home now? Well, can we send him home? It's like a progress report.
Question. At that point, have the parental rights been terminated?
Absolutely not. Absolutely not. The whole goal is to reunify families. So on a permanency hearing, the court will look at the situation and set a goal. The goal could be for the child to remain in foster care, or for the child to be returned to the parents. So if it is for the child to remain a foster child, there are things that the parent is going to be asked to do before the next court date to try to achieve that return home goal. So, if that makes sense, the permanency hearing is just a way for the court to check on the status of the case.
Well, what leads to the termination of the parental rights?
Well, parents are usually given a year, maybe a year and a half, to address the issues that caused the case to come into the system. And because the ultimate goal is to provide permanency for the child within a reasonable time period. If there has not been any real progress over a year, the court might change the goal to start heading towards termination of parental rights. But that gets to, you get to a different legal standard then, because at that point the prosecutor has to show that the parent has failed to correct the conditions. What's the legal standard I'm missing? By clear and convincing evidence. So it's just that's the highest legal bar you can have. By clear and convincing evidence, they failed.
Is it safe to say that the courts are trying to give the parents the benefit of the doubt?
Yeah.
Before the parental rights are terminated.
Right. So
Very good.
They don't ask you to do a whole lot. I mean, there's parenting classes, there's counseling, anger management classes. There's all these programs that you can engage in to correct the conditions that cause your child to be in the state's custody.
Well, Crystal,
so it's just a last resort.
We got about 30 seconds, my friend, and it's so good to see you. The last word goes to you.
Oh, God. Let's see. What would I want to?
Well, you got 30 seconds.
I got 30 seconds. Time's up. Call the Bar Association if you have any further questions. We'd like to help if we can.
Very good. God bless you. We'll be back the same time, same station.